Are you looking to buy or sell agricultural land, especially in Telangana? Are you wondering about what clauses that are commonly missed out in these agreement of sales documents that create confusion and problems later? If you're looking for those clauses that are generally missed out in an agreement of sale for agricultural land in Telangana, then you're at the right place. In this video, I'm going to be talking about 3 such clauses which are commonly missed out. Hello everyone, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal concepts. For tips, tricks and more legal information, make sure to hit the subscribe button below. Clause number 3 that is generally missed out, or a clause that should definitely be included in an agreement of sale when buying agricultural property, is that the seller of the particular land or that particular agricultural property, he must say that he is the owner of that particular property, or he must make a representation to that effect. The key language is he must say that he has clear and marketable title over that agricultural property. He must also say that there are no loans on the particular property, or that particular agricultural property is not mortgaged with a bank. Another important representation to take, especially if you're in Telangana, is that the agreement of sale must say that the land is not Waqf property, or that there are no protected tenants in that particular property, which may come back to bite you later, especially if you're a buyer. Clause number 2 is termination and refund. So let's say, for example, that you enter into an agreement of sale on the 1st of January, you want to close this deal by the 31st of March. So you have 3 months. Now, before you enter into the agreement of sale, you've done your due diligence, you've checked the papers of the property, and it looks okay to you. But once you enter into the agreement of sale, so let's say you're buying it for 2 crores, you paid 1 crore, this balance of 1 crore to be paid by the 31st of March. So you paid 1 crore, and then you find out, before you pay the balance amount, that there's some defect in the title to the property, or that there's some problem or there's some issue because of which you could not foresee at the time of entering into the agreement of sale on the 1st of January. So at this stage, you want to back out, right? So you want to have a clause in the agreement of sale which says that, if I find a defect in the title to the agreement of sale, then I want the ability to back out from the deal, and that I will not come forward to execute the sale deed because there's a defect, and if there's such a defect, then I want you to refund the 1 crore that I have paid you. So this is if you're the buyer. Now again, if you're the buyer, so let's say you hit the 31st of March and the seller is still not coming forward to sell the particular property to you, then you want an option, right? You want the option to say, as the buyer, I have the choice either to ask for a refund of money because, if you're not interested in doing the deal, give me my money back, I'll just go find some other property. Or you want to retain the option to say, if you don't do the deal by the 31st of March, I am going to sue you for specific performance. I am going to sue you in court, seeking a direction in court against you to come forward and execute the sale deed. So you want to retain the option either to get the money back or to sue for specific performance. On how to sue for specific performance, there's a separate video that I've made on it. Make sure to click the link above. Now, on the other hand, if you are the seller and you've received 1 crore, you're on the 25th of March and you're telling the buyer, please come and pay the balance money so that I can do the sale deed in your name because you may have another purchase of property lined up, or whatever, but you want to close this deal. In such a situation, you want to retain the right to say that, look, if you don't come forward by the 31st of March to close the deal, then I will forfeit the money that you have paid to me. So the 1 crore that you have paid to me, I will retain that money with me and I will not refund it back to you because you have not come by the 31st of March. So that way, at least you create some fear in the buyer to make sure that he adheres to the timelines. The number one thing that you must be careful with when you are drafting an agreement of sale for agricultural land is to make sure that you get the schedule of the property right. The schedule of the property is basically the details of the property that are given in the agreement of sale. Because if you're the buyer, you're paying 2 crores. What are you getting in exchange? You're getting this parcel of land. So you want to make sure that the details that are given, that those details are clear. So you want to say, I'm buying say 2 acres in so and so survey number, in so and so mandal, in so and so district, and that all the boundaries are right, north, south, east, west. And boundaries are extremely important when you're looking to buy agricultural land, because these open lands, they have a tendency to have more disputes with boundary lands, with your with boundaries, if with your neighbor, and so on. So you want to make sure that you get the boundaries right. The other thing to make sure is that, if there are two people who own 2 acres jointly, which is they own 1 acre each, and you're buying just 1 acre from one person, you need to understand that what you are buying is, first of all, you can only limit your purchase to 1 acre, because they hold 1 acre each. So you can't buy 2 acres from one person. And the other thing to understand is that what you are actually buying when you're buying from joint owners is that you're buying an undivided share in the property. So when you get possession, you can't on your own create a particular boundary wall for 1 acre and say this 1 acre is mine, because the original owners, both the owners, they have not partitioned the land by metes and bounds. That's what they call it in law. Basically, they have not segregated which portion belongs to whom. So therefore, when you enter into an agreement of sale with joint owners, with one of the joint owners, then what you get is you get an undivided share in the 2 acres, and the details of each share will not be mentioned when you do the agreement of sale. Make sure that in the boundaries, you will have the boundary for the entire 2 acres. You won't have boundaries for just 1 acre, because it has not been divided yet. So it will say that you own 1 acre out of 2 acres as undivided share in the entire 2 acres. And in the schedule, the boundaries of the 2 acres will reflect not the boundaries of 1 acre, because it has not been divided yet. So that's something that you need to be careful with, especially if there are joint owners to a particular agricultural land. I hope this video was helpful. If you want a more detailed video on what are all the clauses that should be included in an agreement of sale, make sure to click the link above. Thank you for watching.